end game is from where I'm going. So when we talk about day four, okay, they had some arguments about Snapchat, some videos, and some pictures, and when they're going to put this in or not put that in. And I think some of the defense's arguments in opening statement um, that the state is now using against him is good lawyering by the state. He said, this stuff shouldn't come in, Snapchat, these videos, you can access it from all different devices. And she said, Judge, the defense made it clear we have to prove every single thing in this case beyond a reasonable doubt. He's not admitting that it's his phone, so I don't expect him to admit it's his Snapchat and connecting it to his phone. We don't want any stipulation. We want to prove all this. And the judge eventually, after taking it under advisement, decided a lot of the Snapchat stuff is going to come in. What's not going to come in is any firearms in the Snapchat video. The state tried to argue he has access to the weapon just days before. Judge said no. I feel like in Murdoch, they're like, yeah, we'll let it in. Number two, no flashing cash or anything like that. That's more prejudicial. And no titles or lyrics from the song Murder on My Mind. So a lot of the Snapchat stuff is going to come in. Some of it came in with Miss Holmes today, but that was kind of the first argument that was had between them. And the defense lost that ruling. And so when some of the Snapchat stuff came in, the defense made their objections. When the judge overruled their objections, the defense allowed the testimony about the Snapchat. And the defense sat at counsel table and took the L. I promise you, the defense attorney at one point kind of laughed or was like, when the judge made a ruling, the judge is like, is that something funny? And he's like, I apologize, Judge. I didn't mean any disrespect from it. I respect your rulings, whether I agree with them or not. Totally appropriate. A great job by him. Again, I'm not saying he's going to win. I'm not saying anything about that. I do not know him. So, but when that evidence came out, that I promise you the defense disagreed with the fact that it was coming out, took the L, they sat at the defense table, they continued to fight for their client, they continued to make arguments. First witness, GSR expert. There was some GSR on Cortland Henry's hands. She didn't test Cortland Henry's clothes, and she doesn't know if he washed his hands because he could have washed most of it off. So there was some, but not a ton, of gunshot residue on Cortland Sutton's hands. Cortland Henry. Cortland Sutton is a wide receiver. On Cortland Henry's hands. That was basically it. Then we get to, again, the defense attorney. John, stars some of these questions too so I can get to them later. We get to the defense attorney's first mention of the fact that he thinks the state is going to call a witness just to ask questions about a statement that has been recanted, just to impeach her, just to read her prior statement into the record that is not a deposition, and that the statement doesn't, or that the witness does not remember giving and does not remember whether it's true or false. Okay? At the very beginning, he asks, what is take the L? Take the L means you lose. Like, you're going to win some arguments in court, you're going to lose. It's like being a bad winner, bad loser, bad sport in sports. If you lose a game, the team was better, whatever, you take the L, you high five, you move on, you get better. In this case, the defense attorneys lost the Snapchat argument. Take the L, keep fighting. We're going to get to a lawyer who could not take an L on an evidentiary ruling later. So the defense attorney, again, before this